Welcome, everybody. My name is Matt Johnson. I'm counsel to the New Hampshire Realtors. I'm also a shareholder at Divine Milliman and Branch. This is the next installment in our Risk Management Back to Basics video series. The topic today is the inspection process from the buyer. I'm delighted to have with me the chair of the Risk Management Subcommittee, Jim Lyons, who will help us walk through this process. So this is a major step in the transaction. This is the inspection process from the buyer perspective. I will note that this has some significant legal implications to it. One of the major contingencies in the purchase and sale agreement is the contingency for inspections. There's a section in the purchase and sale agreement that goes into detail about this. It is important to set reasonable deadlines in terms of time to complete inspections and time to deliver the results to the seller, because the contract does say time is of the essence. And what that means is the courts will enforce strict compliance with those deadlines. If it says by October 1 and you do it by October 2, you are late, and the buyer has waived that ability to get out of the transaction because of issues related to the inspection. The other aspect of legal significance is there is a waterfall of activities that happens once those results come in. The buyer can decide they're fine and just waive the contingency. The buyer can also alert the seller to issues they have with the property, and then that sets up a negotiation between the buyer and the seller. They can reach agreement. The buyer can decide, guess what, I'll waive my objections and just take it as is, or they cannot reach agreement and the deal will terminate. So this often ends up being the second round of negotiation over the home inspection process. So it is a significant event. It is only supposed to be triggered if the buyer during the inspection finds a significant issue or defect that was not previously disclosed. And I emphasize the not previously disclosed. I think that's the most significant part. If you're complaining about something that was on the seller disclosure, that's not really what this was intended to cover. However, if you find issues with the house that you didn't know about, chances are they're going to be significant. That word is a generalized word. And typically speaking, in my experience, the courts will interpret significant to be something that's significant to at least your average buyer. So that's the rules of the road. That's the legal framework. Jim, from a practical perspective, when you're doing a home inspection and you're representing a buyer client, what role do you play? How do you go about it?
Well, typically, Matt, I like to have a conversation with my buyer clients coming into the inspection before the home inspector arrives, and I like to explain to them that it's their inspection, and that while I physically want to be there in case they need me, I want the inspector to feel totally at ease, conveying any concerns or that they may have with the buyer, and I don't want to influence that. So if I'm there following them around very closely, puppy dogging them around the house, the inspector may not feel as comfortable in his discussion with the buyer as they would if I was sitting at the kitchen table doing work. So typically that's what I do. I distance myself, and if they have any concerns, they'll call me, and then I'm there to wrap up. And at the end of the inspection, obviously, if there's any, quote, significant defects, I want to be able to see them so that I can explain them to the listing agent, because it may, as you indicate, be a matter of negotiation.
And so, and now with respect to the inspection and the inspector, do you have any suggestions or advice about the role of the agent in helping to procure the inspector or select the inspector? What practice do you follow?
Well, absolutely. In my firm, we would practice the role of threes. So anytime we're going to provide a reference or a recommendation, we want to give out at least three names. We don't want any perception by the buyer to feel that there's any relationship and that we're steering them, if you will, to a particular firm. So generally speaking, of course, you have the internet, and so consumers can find everyone in the area if they choose to on the internet. But generally what we do here is our local board of realtors has an affiliate. We have a lot of affiliates, and we have quite a few affiliate members of the White Mountain Board of Realtors, and we have an affiliate brochure, which I email out, and that has lenders, it has attorneys, it has, so in any aspect of the transaction, the buyer can easily reference that for choices if they choose. But we will always give out a minimum of 3 names. I'll not steer a buyer into one particular home inspector. Just talk about, if they may ask me, for instance, what experience I have, I'll just tell them that they're local, they do a lot of inspections in the area. But always the rule of threes.
I think that's a great rule from a liability perspective. I would find it very hard to find a buyer, a broker, or an agent getting liability for essentially like negligent retention or negligent hiring if you've given multiple options and the consumer gets to choose. So I think that very much is a best practice on that. The other thing I just would reinforce too is that issue over significant defects. The resource line gets questioned sometimes about, well, the buyer is complaining about X, and I don't think that's significant. I would just emphasize that significant is in the eye of the beholder. The buyer is going to have the significant issue. I'm hard pressed to come up with scenarios where it would be so minor that I would have a hard time saying it's significant. For the most part, it is going to be significant. And secondary to that, the buyer's agents, if they're helping the buyer the right way, are only going to be putting things on the list that really are meaningful and significant, because once they send that list, the seller can say, no, forget it, I don't want to do it, so they can run the risk of losing the transaction. Would you agree with that, Jim?
Yes, I do. Also, I have a question for you with respect to resolution of the inspection contingencies. Do you believe it's important to resolve those in writing to get a communication from the buyer after the inspections have been done? Obviously, if the buyer says, I'm fine with everything, what kind of documentation do you recommend for realtors in that respect?
Great question. So in the internal relationship, if your buyer says, you know what, I've read the inspection reports, I'm good with them, I would get that at least in an email and save that in your file, because by saying that, that's authorizing you to essentially not give anything to the seller and thereby waive that contingency in the purchase and sale agreement. So I would want to have that written back up. On the second side of that, if they do have questions or do have issues, I think you do want it in writing, and any resolution of that needs to be in an addendum. And I frankly have seen plenty of litigation or disputes arise over compliance with the terms of what the parties thought they agreed to in terms of what the repairs to the property were going to be. So that addendum needs to be drafted carefully. And I don't think it's necessarily drafted carefully from a legal perspective, but it needs to be drafted carefully from a practical perspective. So it's very clear, is someone performing work? Is someone paying for it? If there's an item that's being fixed, what is being fixed? More detail is better than less detail on that to avoid confusion. So that's a great question, Jim, and great job. Thank you for that. Very good information for our viewers, and that concludes this segment of the Back to Basics video.